Good evening, my friends. This is Mark Levin. There's no way around it anymore. What he told Joe the plumber a few weeks ago, what he said 7 years ago, the one constant on the public record for Barack Obama is that he wants to redistribute wealth, and not of the rich and the mighty, your wealth. Look wherever socialism exists. Who suffers? Who's denied the benefits of their labor? The middle class. Now, you don't have to believe me. You can believe Barack Obama, and if our media were worth the First Amendment that protects them in this country, they would be leading with this on all the network broadcasts tonight, but they won't. As a matter of fact, some places, some websites like Politico.com and so forth, they downplay it. It's Republican tactics, opposition research. And so we're not to pay attention to the substance of what Obama says and who he is. This is 2001 WBEZ Radio, public radio, redistribution of wealth, cut one, go.
You know, if you look at the victories and failures of the civil rights movement and its litigation strategy in the court, I think where it succeeded was to vest formal rights in previously dispossessed peoples, so that I would now have the right to vote. I would now be able to sit at a lunch counter and order, and as long as I could pay for it, I'd be okay. But the Supreme Court never ventured into the issues of redistribution of wealth and sort of more basic issues of political and economic justice in the society. And to that extent, as radical as I think people tried to characterize the Warren Court, it wasn't that radical. It didn't break free from the essential constraints that were placed by the Founding Fathers in the Constitution, at least as it's been interpreted, and Warren Court interpreted it in the same way that generally the Constitution is a charter of negative liberties, says what the states can't do to you, says what the federal government can't do to you, but it doesn't say what the federal government or the state government must do on your behalf. And that hasn't shifted. And one of the, I think, the tragedies of the civil rights movement was because the civil rights movement became so court-focused, I think that there was a tendency to lose track of the political and community organizing and activities on the ground that are able to put together the actual coalitions of power through which you bring about redistributive change. And in some ways, we still suffer from that.
All right, there's a lot here, and all of it's bad. First of all, the civil rights movement was not a court movement. It started in black churches. Martin Luther King was not a lawyer. Martin Luther King was a civil rights leader and an activist. But for what took place in those churches and later what took place in the streets, there would have been no court action. So as a matter of history, he's simply wrong. Now, obviously the court issues followed, as did the legislative matters follow. The Civil Rights Act of 64, the Voting Rights Act of 65. Even before that, the first Civil Rights Act was passed in the late 1950s at the behest of President Eisenhower. But putting all that aside, there's two things I want you to focus on. Obviously, the redistributive change, in other words, economic socialism. And the Constitution is a charter of negative liberties. The Constitution is not a charter. It's the law of the land. It's our social compact. There is nothing in the Constitution, nothing, that advances the cause of slavery. As a matter of fact, to the extent they could, given that the colonies did include slave states, the Constitution put obstacles in front of slavery, whether it was the 3/5 vote, meaning 3/5 of the South represented in the House of Representatives. Blacks were counted as 3/5 because the North insisted on it. And the North insisted on it because the North said, look, if you're not going to treat these people as people, then you don't get to count them to increase your numbers in the House as a full person. So the purpose for the North was to weaken the South's political clout. There was also a provision in the Constitution ending the importation of slaves. in a time certain. And there were other provisions as well, but those are the essentials. So he has the Constitution wrong. In addition, the Constitution set the foundation for societal changes. Most of the framers were, very uncomfortable with slavery. Even some of those who actually had slaves and released them upon their death. Big deal, Mark. Well, it was a big deal at the time. Nothing justifies slavery. Nothing ever could. And many of the framers even wrote about that among themselves. And it is a dark time in our history, from a legal point of view, that we had slavery at all. But it's not the Constitution's fault. No, it's not. In fact, the Constitution, in my view, combined with the Declaration of Independence, ended it. Now, if you don't accept that history, then you're accepting a very different and radical point of view about your own country. Now, this thing about redistributive change, that the Warren Court wasn't all that radical, what he is saying is, what the court should have done from Obama's point of view was impose socialism from the bench. Now, what does he mean by that? The 14th Amendment, due process and equal protection clauses. This is a new theory, actually not that new, maybe a decade or two, going around in our law schools, including University of Chicago, where Barack Obama's legal advisor and close friend, Professor Cass Sunstein, works, and who has a shot at going to the Supreme Court if Obama wins, Cass Sunstein. And there's also other professors, Bruce Ackerman at Yale and Robin West at Georgetown. What they are promoting is that the 14th Amendment, the purpose of which was to ensure that blacks would be treated as citizens once and for all, that the 14th Amendment be used, equal protection and due process, to compel, as a matter of constitutional law, the socialist agenda. In other words, constitutionalize redistribution of wealth. That's why Obama is saying, well, the court wasn't really that radical. The most radical court in American history, the Warren Court, to Obama wasn't that radical at all. Think about that. The most radical court in American history wasn't all that radical at all, according to Obama. So in this one statement, he talks about a defective Constitution. He talks about what the Constitution should do, not what it does do. He talks about redistribution of wealth. Does that matter to any of you? Any of you who haven't made up your mind or who are supporting Obama, does that matter to you? This is a radical point of view, far outside the American mainstream. It is a foreign approach to the rule of law. If the Constitution's meaning can be erased or rewritten, as Obama suggests, and the framers' intentions ignored, it ceases to be a constitution, but instead a concoction of political expedients that serve the contemporary policy agendas of the few who are entrusted with public authority to preserve it. This is tyranny's disguise. These are not rights he's talking about. They are the left's false promises of utopianism, which the left uses to justify all trespasses on the individual's private property. Liberty and private property, because what we're talking about, he uses the phrase economic justice. That's socialism. That's what's meant. It's a term of art. Liberty and private property go hand in hand. By dominating one, the leftist dominates both. For if the individual cannot keep or dispose of the value he creates by his own labor, then he exists to serve the state. When the law has exceeded its proper functions, it is not done so merely in some inconsequential and debatable matters. The law has gone further than this. It has acted in direct opposition to its own purpose. The law has been used to destroy its own objective, It has been applied to annihilating the justice that it was supposed to maintain, to limiting and destroying of the unscrupulous who wish, without risk, to exploit the person, liberty, and property of others. It has converted plunder. It has converted plunder into a right in order to protect plunder. And it has converted lawful defense into a crime in order to punish lawful defense.